Okay, I want to talk to you about this law called ignorance of the law. All right. In law, ignorantata juris non excusat, Latin for ignorance of the law is no excuse, is a universal principle holding that a person unaware of a law cannot escape liability for violating it merely by claiming that they did not know it existed. Now, like I said, I like to read and studying democracy and etc. And well, here's the history of it. uh, Ignorance of law is no excuse. A legal principle holding that a person is unaware of the law may not escape liability for violating that law by being unaware of its content. European law, countries with a tradition of Roman law, may also use an expression Aristotle translated into Latin, nemo centura ignorant leum. Nobody is thought to be ignorant of the law. Okay, so ignorance of the law goes way back. A Roman law derived from customs of Italian tribes, and these customs had rules reasonable people would know. Ignorance was not a defense. Okay, so ignorance of the law goes back a long way to where they can't use it. Okay, so you can't use, in a court of law, ignorance of the law is no excuse. Okay, so let's go to where qualified immunity started and why. Qualified immunity, a judicial standard created legal doctrine that shields government officials, including police officers, from civil liability in lawsuits unless they violate clearly established statutory or constitutional rights. Oh, okay, so you see that, they have no excuse because they're constantly violating your constitutional rights. All right. Right was clearly established at the time of the incident. Okay. So who can claim ignorance of the law when they knowingly and willingly violate? Okay, so let's put when did qualified immunity start? Oh, sorry. Qualified immunity. Started in 67. Originated from a 67 Supreme Court ruling involved to require plaintiffs to prove the exact action was previously deemed illegal. The legal foundation for suing government stems from the Civil Rights Act of 1871, declared as enacted during Reconstruction. The statute was originally designated to combat racial terror by the Ku Klux Klan and hold state officials accountable. The origin and the impacts of this law are thoroughly analyzed in the Defense Fund. The birth of the doctrine, the Supreme Court formally established qualified immunity doctrine, is a seminal case, Pearson versus Ray. That was started in 61. The case involved 15 clergymen, both black and white, who were arrested in Jackson, Mississippi for attempting to integrate a segregated Trailways bus terminal waiting room. After the charges were dropped, the clergymen sued the arresting officers false arrest under Section 1883. The Supreme Court ruled in favor of the officers, concluding that they could raise a good faith defense where they were not liable if they reasonably believed their actions were legal. More details. So they arrested these guys because of the sign on the wall said no mixing, blacks only, whites only, and so the cops thought this was a law, so they arrested them for breaking the law, and they didn't want to go along, so they arrested them for disturbing the peace. but it was the police that were creating this disturbance because of race mixing. And they said, well, there was Jim Crow law, but Jim Crow laws were anti-rule of law, in violation of the Constitution, so thus they were ruled unconstitutional. But these laws were made, they were not in the public interest. They were in line 12 of the Rules of Professional Conduct. It clearly states that lawyers are to act in the public interest, not in furtherance of parochial interest or self-interest of the bar. And it was in the self-interest of the bar to keep this fight in court because, billable items. But either way, these Jim Crow laws were anti-constitutional, not just unconstitutional, intentionally anti-constitutional. And you know that the United States Constitution is the law of the land, and no law contrary, repugnant to the United States Constitution can stand it. It is void. So even trying to establish it is un-American. So here you go. They said that these cops didn't know the law, so they can't be held responsible for arresting somebody for something they thought was a law, but wasn't. Under their modern interpretation, officials are granted qualified immunity unless existing precedent in their specific jurisdiction has already declared the exact conduct unconstitutional. If there is no previous case with validity, identical circumstances, officers are generally shielded from a lawsuit. The evolution of this legal doctrine and arguments for restriction are discussed in depth of Georgetown law. Okay, so they were ignorant of the law. They didn't know that Jim Crow law was unconstitutional. They didn't know it violated the rule of law, the king of laws and a nation of law, the very principle, the very foundation of the Declaration of Independence, the very definition, or gave definition to our Constitution. It started years before that in the history of the Magna Carta. How does one not know segregation violates the rule of law? It's common knowledge. But because of their ignorance of the law, they were given qualified immunity. So if ignorance of the law is not an excuse for you, okay, it's no excuse for you in a court of law, but for them it's qualified immunity. And that's where this term comes in. In legal, journalistic, and government contexts, actions or disclosures deemed not in the public interest fail to contribute to the democratic accountability, public safety, or the purpose of wrongdoing. Instead, they risk causing genuine social harm, compromising an ongoing criminal investigation, jeopardizing national security, or breaching personal privacy without proportional social benefit. So, not in the public interest, y'all. Them getting qualified immunity for their ignorance of the law. But if we were in a court of law, they would tell us ignorance of the law is no excuse and still lock us up for it. Not in the public interest. Definitely not in the public interest. Let me know what your thoughts are, all right? I just like to throw laws together, what they call legal loopholes. They're not legal loopholes. They're doors just left open. The intentional screen door on a submarine. Quite useless. Redundant. How is that not violating the rule of law? Your thoughts, people. Your thoughts. That's all I want. All right? Your thoughts and the contradictions, the egregious contradictions in our legal system. not in the public interest. Nothing but love for one and all. My people, we the people of the United States of America. I wish you a long life and good health. May your Creator always rain many blessings. Peace and love. Y'all know, but peace and love. Happy 4th of July.